I'm Jenny Mattingly. I'm with the Partnership for Public Service. I'm our Vice President for Public Policy and Stakeholder Engagement. And got with us our partners on our town hall efforts. We've got AFGE, Rise Up Legal Network, and Civil Service Strong. For those of you not familiar with the partnership, we're a nonpartisan nonprofit working to build better government and stronger democracy. We do that through supporting federal workers and those who were recently in the federal service, leadership development, programming, and really convening and thinking about policy solutions to make government work better. You will also hear more from our partners this evening about what they're thinking about, what they're doing, and resources that we all have for you. But before we jump into everything, a couple quick housekeeping items. Please feel free to submit questions through the Q&A function, and we will do our best to answer what we can get to. But given the complexity of the topics, we may not be able to address every single question or associated circumstance that you put in there, but know that we are looking at them. To the extent that we can answer, we will, and we will continue to put out resources. We'll be sharing some tonight, some great FAQs that these groups have put together on Schedule PC and other issues. And we'll have other town halls in the future as well to dig into things. If you miss something tonight, or if you know others who couldn't be here, this is being recorded right now, so we will share it out after, and it will be on our website. Our partners here also often have them on their website, so you will be able to see this again. And we all have a lot of other good resources on our various websites as well that might be of interest. So at any rate, we will get to the meat of the discussion now. And as you know, we're just discussing schedule policy career. We've definitely brought this up in other webinars and town halls that you all may have been on. But on June 3rd, President Trump signed an executive order that formally transferred positions into Schedule PC. And so we'll talk through some things tonight about navigating the acknowledgement forms, what we know and don't know about the reclassifications, things to still look out for, and current status of litigation. So with that in mind, I will introduce our panelists very quickly. And we'll get started. We've got Mike and Rob from Civil Service Strong. I think many of you have seen them on our town halls before. We've got Rushab with AFGE, and we've got Suzanne and Laura from Rise Up Federal Workers Legal Defense Network. And Laura, you are a new face to these. I know the rest of us have done several town halls, but you are brand new as the executive director, and would love to give you a chance just to say a few words about Rise Up and share some resources.
Thanks so much, Jenny. Thank you. Thanks for inviting me, and it's really great to be here. My name's Laura Padine. I'm the Executive Director of the Rise Up Federal Workers Legal Defense Network. We're an organization that was founded by unions and democracy groups to provide legal support to federal workers facing firings, forced relocations, and other violations of their rights by the Trump administration. We do this by organizing online legal clinics where we match volunteer lawyers with federal workers who need a legal consultation so that they know their rights and the best avenue for enforcing their rights. So I want to encourage every federal worker who is facing unfair or legal treatment at work to go to our website. It was just dropped in the chat, and sign up for a legal consultation. And we also want to hear from you about the big policy changes that are happening in your workplace that may be harming your ability to do your job, whether policies like Schedule PC, which we'll be discussing today, forced relocations, non-disclosure agreements, any of that, because we can also do more communications like this one, webinars, fact sheets that reach a broader audience of federal workers. So I can drop my email in the chat so you can contact me with any suggestions or just reach out about big issues you're seeing in your workplace. So thank you for that. And I will turn it over to Suzanne Summerlin, our general counsel, who will start the presentation.
Thank you, Laura. So we are going to start tonight with the question. It was the first question. We already got it in the Q&A. So just like right on schedule. Perfect. Thank you for that. It is the biggest question that we are seeing at Rise Up right now, which is, I received an acknowledgement form about schedule policy career. what do I do with this? So let's walk through what this form is and the options that you have, because ultimately this is a personal decision that every Fed who receives this will have to make for themselves. So first, what is this form? When your agency moves a federal career position into Schedule PC, it is required to notify the person who holds that position, that worker. And this is per OPM's implementing regulations. So the acknowledgement form is that notification that is required by the regulations. It's an agency telling a worker your position has been identified for reclassification into Schedule PC. Please sign here to confirm that you received this notice. It is just a receipt. Now, the question on everybody's minds is, if I sign this, am I going to be okay? Am I giving up some rights that I have, or am I somehow accepting that Schedule PC is legal and that what's happening to me is okay? And the answer is no. And here's why. Schedule PC does not get its legal effect from your signature. It gets that legal effect, or at least purports to get that legal effect, from the executive order and from OPM's regulations, which Mike and Rob are going to get into. Those documents, exist and operate whether a worker signs anything or not. So if you need to think of it like signing a certified mail receipt, signing it means you received it. It does not mean you agree to the information that it is within it. So what are your options, and what does each one mean for you? You have 3 options approximately. If you sign the form, you're acknowledging receipt, you're not waiving any legal rights, and you're not conceding that Schedule PC is lawful. The courts are going to decide that question, and Rashab is here to talk about that litigation. So we will talk about that tonight and the status of that. So the courts are going to decide regardless of what is signed. If the courts strike down Schedule PC, the idea is your rights are going to be restored no matter what. Your signature has no bearing on the outcome of those court cases. Now, refusing to sign could be treated by an agency as a failure to comply with a reasonable workplace directive. That is a separate issue from Schedule PC entirely, and it could result in an adverse action, not because of the reclassification, but because of the refusal to acknowledge it with your signature. So that means you could face discipline on top, of everything else you're already navigating. That is a real risk. Folks who are being moved to Schedule PC are already made more vulnerable by that move, and they lack civil service protections they would have had previous to that move. So refusing to sign does carry a real risk, and it's one worth weighing carefully, I think, before making that choice. Similarly, if you choose to sign the form but add a comment or annotation, folks are tempted to write things like receipt only, I don't agree to this, or I'm signing under protest. Unfortunately, that does not actually provide you any sort of legal protection. So no court has recognized like an annotation like that is going to preserve some sort of additional legal rights beyond what you already have. And we talked about that, in answering the first question, which is like the courts are going to do what they do regardless of who has acknowledged their move or not. So you're not getting any extra legal protection here. But what it does do is signal resistance to whoever is in your agency that processes that form. And it might draw attention that you're not looking for. So this is a personal call. Some people feel very strongly about making their objection known in writing. I totally understand that. I sympathize with that. I would have a hard time personally signing it, so I totally understand. But we do want you to go in with eyes open about the risk and about the limited legal benefit that any sort of annotation would provide. So RiseUp's general recommendation is to sign the form without annotation. That's the path that, we believe protects you from immediate risk while preserving all of your legal arguments that are going to be made in litigation, which is where they really count. So we recognize that this is your choice to make, and that different people will weigh these considerations differently, of course, based on their own situation. Now, if you are uncertain about a specific form that you've received, or if you've already refused or annotated and you're kind of wondering what your exposure looks like, these are the kinds of questions that we can help you with at RiseUp. Your unions can help you with as well. Please, avail yourself of the various resources that we will talk about here today. And in the meantime, I will hand it back over to Jenny.
Great. Thank you, Suzanne. And I think that's, one of the things folks are asking about is what to do, because they don't, they've been moved to PC. They're not getting information from their agency. And I think to the point that you and Laura made, Rise Up is there. You can go talk to folks, go ask these questions because everybody's circumstances might be different. And so, or go talk to your union and we'll hear more about that as well. So that's certainly something to be thinking about, is going and asking, seeking out support. And there is a lot of it on here, and we'll talk a little more about that. But before we get into that a little more, Rob, Mike, you're here. Civil Service Strong has been thinking about this. I know you all have resources, and you've been looking at who's impacted right now, because I do think that's also a question, and people are asking, why was I put on PC versus other people? Can you talk a little bit about, the reclassifications and what you're seeing about that?
Yeah, sure. Thanks, Jenny. And just for anybody who might be new to the town hall, Civil Service Strong is a project at Democracy Forward. Democracy Forward has been heavily involved in litigating against the Trump administration to advance the rule of law and protect the rule of law. I think we've brought over 400 some legal actions, including a lot of litigation around the civil service and specifically around schedule policy career. Civil Service Strong is a program that provides support to civil servants in addition to the litigation work that Democracy Forward is doing. We work with the folks on this call and other organizations to help provide resources and other ways of supporting feds. And we also are working on reimagining a future federal government that works better for all people. So you can reach out to us if you want to be involved in any of those efforts. I wanted to turn it over to Mike to get into some of these detailed questions, but before doing that, I just wanted you all to know that there's been extensive work done on this topic prior to what this administration has done. And I wanted to call your attention to regulations that OPM did during the Biden administration in the wake of what was then called Schedule F, to clarify what civil service protections apply to federal workers and what the laws mean that have been in place for many, many years and many, many decades in some cases. And so we'll drop a link into the chat for the final regulation that we did back in 2024. It's lengthy, but it has a lot of helpful background about where these protections come from, why they're important, and why at that time, and we continue to think that schedule policy career is both bad policy and contrary to law. And we will get into the legal discussion a little bit later on, but just wanted you to have that resource as background for the conversation. And I'll turn it over to you, Mike, for the questions that Jenny's raised.
Yeah, and I think it's thanks, Rob. And I'm Mike Martinez, Managing Counsel at Civil Service Strong. I was formerly at OPM as Deputy General Counsel. I work closely with Rob and others there in efforts to stop what was then called Schedule F and is now Schedule Policy Career. But I think throughout this webinar, you'll hear us talking about the 2024 rule, the Biden era rule, and the 2026 rule, this Trump era rule, and how they're different. But one thing that I want to highlight, because I've seen it now in the questions, is there's a lot of questions about why was I included? My position is not a policy position. I think that really goes back to what is schedule policy career. And the way I like to explain it is that most civil servants, if they're not in a trial position period or a probationary period, have adverse action protections. So you have protection from termination. The SES has its own set of protections. But there are some exceptions about that Congress put into statute. And they're what you would expect, presidential appointments, Senate confirmed positions, and there was Schedule C positions. And there's a phrase called confidential policy determining, policy making, policy advocating. And for decades, that has meant Schedule C type positions that are political appointments that end at the end of an administration. This administration, in its first iteration in 2020, and then again in 2025, took the position that those words mean whatever they say they mean. So policy determining, policy making, policy advocating. So it's a wide breadth of possible positions. And when Schedule PC was rejuvenated in 2025, in an executive order, the president directed agencies government-wide to look at their positions and take a broad look at what could possibly be put into Schedule PC. So for many months, agencies did that, and they recommended those positions to OPM. OPM held them and did some sort of analysis, and then presented positions to the White House. The White House then decided to put positions into Schedule PC, which is what we saw a few weeks ago now, a few days ago. So that's what you see in the executive order that came out in about June 3rd or so, and it has an appendix of positions. So what we saw in that appendix are about 4,800 positions, impacting approximately 8,000 civil servants. So I get the frustration and the confusion of, why was I actually included in this when I don't work on policy. This administration has taken a very broad look, and if you influence, if you touch, if you are in the chain, if you have any sort of nexus to policy, it's possible that they would consider you as this pool of eligible Schedule PC employees. So that's really what happened. Just to highlight some of the positions moved in, the top 3 agencies that moved positions in were Department of Defense, HHS, and DHS, in part because they are some of our larger agencies, but they took a broader scope of what could be a Schedule PC position. And you have what you would expect, supervisory management level GS employees that are not in the SES, but you have some that raise some questions, some scientific positions that don't have a clear nexus to policy. You have a lot of HR professionals who were scooped into the Schedule PC. So we and others, I know the partnership is looking at some of these positions and trying to figure out some sort of thread of why certain positions were included. But I think that's the broad brush take, is that they included higher level folks not in the SES. And I mentioned the SES because SES has its own set of adverse action protections. So SES employees cannot be put into Schedule PC. A couple of things too to look for, and there are various OPM guidance documents that I'd like to highlight. There are at least 3, 2 that came out in February, an initial round, a follow-up round, and then one that came out a few days ago in late in June that describes to civil servants and to agencies how to actually implement Schedule PC. You have to remember that agencies, this is all new for them too, and they're trying to figure out how best to handle it. So I encourage you all to take a look at those guidance documents if you haven't already. There are various FAQs in there that are helpful. And there are other slide decks that are meant to inform employees and HR professionals and agencies on how to actually deal with Schedule PC. But I'll pause there.
Mike and Rob, thanks for that. A couple things that have been on my mind as I've been chatting with folks about Schedule PC is a couple things. One, its positions moved into the executive order, not people. And so just for folks wondering if they're on it or not, the 8,000 number that you mentioned, and I think we'll go and dig in more about what we don't know, but people we may not know the full scope yet of who all's been there. People should have gotten notices as far as I understand, but
yeah, that's right. The executive order that came out a few days ago gave agencies 7 days to inform individuals that they were moved into Schedule PC. So unclear if they stuck to that timeline, but I think that's a good marker on the calendar to look out for something like that.
I think another question that's in the chat, and Mike and Rob, I don't know if this is something you all want to answer, or I encourage anybody else to jump in from our guest tonight. Somebody was saying that their agency has been reorged, and we know a lot of agencies are facing this. So their PDs are out of date. They don't have new PDs yet with new positions, yet they've been notified that they're on Schedule PC. And so I imagine there are a lot of folks, I know when I was in government, my PD was outdated and it didn't really, talk about what I did. And so I wonder, for folks that have either no current PD or other things, is that a, legal question, or how should they be thinking about where they sit? And would it change, I guess, if their PD changed?
I think it's a great question, and I think it highlights some of the complexities here. There are a wide variety of processes that agencies use to update these PDs, and some just are very out of date. what I would do if I were a civil servant is to download my latest PD, download my SF50, and keep a close eye on my EOPF. So that is the electronic portal where you can look for your HR documents and see what the agency is doing, in real time to update those documents. So SF50 especially, that's where the notation would go if you were in fact moved to Schedule PC. So if I were a civil servant, I would look for that.
And Jenny, can I just add one more thing? Is like one of the things that's hard here is Mike has described like the outer limits of what a policy position might be as this administration is interpreting it and how broad that is. But they're not applying that consistently across agencies. There are like you won't be able to find a similarly situated group of people that is like across all agencies deemed to now be in schedule policy career. Like there's a lot of inconsistencies in how they have done that. And those are all issues that the lawyers are looking at. Why is that? Why is there this inconsistent determination of the same statutory phrase that's been interpreted under the same regulation and that is being implemented through the same OPM guidance? So that's another thing that can be frustrating is like it's hard when there is that level of inconsistency, it's very hard to understand where like why your particular position has been classified this way when you may very well know people that have jobs that are in other agencies or even in your own agency that are far closer to policy that have not been reclassified. So that's like I said, these are the questions that the lawyers are looking at now based on how this has been implemented.
And I think, thanks, Rob, for that. And I think one other thing for folks to know, and there's a question about this too, is that this is not the potentially, and who knows if there will be more, but the executive order doesn't limit movement into PC to one time only. And so the executive order and list we just saw is not necessarily the only one that could be there. People are asking, will this happen again? And I think that's a I don't know, and maybe gets us to the next part of this question for you all is what don't we know still about Schedule PC? Because part of this is unknown because it is new and lots of legal questions out there too. So Mike and Rob, can you talk a little bit about what else you're looking for or things thinking through?
Yeah, I'm happy to start. I think one of the big ones is what you mentioned is this it? But I think we should be cautious about that, especially since OPM and its rulemaking estimated that 50,000 individuals would eventually be put into Schedule PC. Who knows if that sticks, because ultimately the White House decides. But I think if it is only 8,000 individuals moved now, I think we should be looking out for further movement. I think the initial groupings in the appendix, I think we're trying to highlight certain positions at a higher level. I think it's entirely possible we'll see others that go deeper into the GS scale to lower level positions. And I guess how agencies would actually implement the executive order and Schedule PC, I think is still being worked out now. I think it's entirely possible that certain individuals moved to Schedule PC will be terminated, and that might be an avenue for some agencies where they'll see some sort of outlet if they have an employee they just want to get rid of. We're starting to hear news about that. Well, one thing that we don't know for sure is exactly how many employees were impacted by this executive order. We have looked at the positions and have some public reporting about the number, but we don't know for sure. I'm not sure that the White House has put any data about how many individuals were actually impacted or where they reside or where duty stations they might be around the country. We have no demographic information. So those are all things that I think will come out, I think, over, as we get into it. And another thing is the civil service protections that exist or don't exist. By the terms of the executive order and by the regulation, there's no further appeal right to the MSPB for indetermination, which is the biggest blow to folks in these positions. That is what the litigation is challenging, at least in part. How they handle EEO and prohibited personnel practices, I think is still up in the air, although there is a process that the guidance documents lay out. So just to get one step deeper into this, prohibited personnel practices would go to the Office of Special Counsel. But this by statute, if you are in a position of a confidential policy making, policy determining, policy advocating role, so Schedule PC, you're not covered by that statute. So OPM and its regulation and its guidance has advised agencies to have their own internal processes for prohibited personnel practices that would go to the agency general counsel's office. So that is new. And then how they actually handle EEO processes, I think it still remains to be seen.
And someone asked an interesting question, and Mike, either to you or Rushab or Suzanne, for folks that are on Schedule PC, if an action is instigated, for instance, they're removed, where can that come from? Because it just says you're at will now. And so we don't know if there's how that might be handled in an agency, I guess. And the question is, do you have any thoughts on if somebody is removed, does that just come from a manager? Does it come from HR? Or is that a complete unknown?
I defer to Rushab or others who may have thoughts.
I think there's two ways to read that question. So that's maybe where my hesitation here is. Like, who can take the action? Like an accusation that leads to an adverse action like removal, I think could come from anywhere. But also, like, who can actually take the action to remove somebody from the federal service? I mean, I think that has to go through the normal channels of, like, your supervisor or whoever that would be in the chain of command. But stop me if you guys think I'm off base here. But that was my instinct.
I'll just add that, we have seen other cases, not Schedule PC cases, with removal notices coming from unexpected places, but they typically do usually come from within the agency chain of command. Again, anything is, we are not certain what agencies will do here, but our assumption is that you will still, if you do get removed and you're on Schedule PC, you'll still receive notification from someone within your agency.
Yeah, and isn't it one more thing to say here? Schedule policy career doesn't change the way that doesn't change the actions that an agency can take. It changes the process that applies once an agency takes that action. So if whoever they would normally go through to carry out an adverse action, as Suzanne was saying, and I mean, unless they create some special rules, we're not aware of that. But the changes to what happens once you get that notice, and Schedule policy career says you don't have any of those due process rights that you otherwise would.
That's helpful. And although question on the due process piece, because when you're talking about that, we're talking MSPB, Merit Systems Protection Board, appeal rights. For folks on the call listening in, because I know we have a question about that, do EEO claims and appeal rights still, is that still an avenue? Do people still have those protections? Not just for Schedule PC, I guess for any of the issues that are swirling out there around protections.
Yeah, the OPM guidance and the FAQs address that. At least they say that it's still an avenue to under Title VII and other discrimination claims will go to EEOC. The question hangs over everything is that whether that's going to be an effective means to the GAF process. That's a separate issue. But at least in OPM's guidance, they say it's still an avenue for even Schedule PC employees.
I think the long and the short of it, unfortunately, is that there's still so many things we don't know about how these play out until we see this going forward. That might be a good place to pause for a moment on some of the questions. And Rushab, we've talked a little bit about litigation. Suzanne mentioned, attorneys and others looking at this. Rob mentioned it as well. Could you give us a rundown of what you're seeing and what's going on?
Yes, thank you, Jenny. So just broadly speaking, I think it's important to highlight why this is important for so many different organizations and why there's a lot of litigation around it, Schedule F or Schedule PC. I think we all know that, a big part of this, and this is what we've been talking about, Rob has talked about, Mike has talked about, a big part about this is, making it so that this administration and so, can more easily remove people and sort of ending or impairing the nonpartisan civil service. And so that with that in mind, AFGE and several other organizations, unions, and our partners have been litigating this. There are many cases pending right now. There is one case by the Treasury Union NTU in DDC. There's another case by the Government Accountability Project, a whistleblower organization in Maryland. And then what's probably the broadest case right now is a case that Democracy Forward is leading the charge on with AFGE, the AFL-CIO, AFSCME, and an organization called PEER, and that's also in Maryland. I think just to make one thing clear, like we've seen in a lot of these other topics, there's still a lot of questions here, and the litigation itself is changing. Many of you may recall that immediately after the Schedule F initial Schedule PC executive order was issued on Inauguration Day, several groups, including AFGE, NTU, filed lawsuits in the weeks after that. But what we initially thought was going to happen didn't happen. Things went slower and changed. And so these lawsuits have been amended, they've been changed. And so where they are right now, most of them are right now in something of a holding pattern. There have been amended complaints filed. There are motions to amend complaints. And we're kind of all assessing what we do next in order to move the litigation forward, and waiting for the government to respond to our arguments. All the cases have slightly different framings, but I think there are a few simple ideas that the arguments the various cases are making can be boiled down to. The first is that what the president is trying to do here is something only Congress can do. If you read the pleadings, you'll hear the term ultra vires a lot, which just basically means that we think the president is acting outside of his authority, and that to make this broad a change, he needs Congress to do it. He can't do it himself. This also ties into another argument made in a lot of the cases, which is this is a separation of powers issue. Then there's also arguments that this is a violation of a law known as the Administrative Procedures Act. When the administration issues rules, those rules have to be consistent. They can't violate the law themselves, and they have to be reasoned. And so all of the cases are arguing that the Schedule PC rule violates the Administrative Procedures Act, both because it's contrary to law, it violates the law to carry this rule out, to transfer these people in the way they are doing, and that it's arbitrary and capricious. There are also claims that this violates the Fifth Amendment right to due process. There is longstanding case law that once a federal employee gets due process rights, he has or she has an interest in those rights that can't be taken away without due process. And so these are the general arguments that are being made in this litigation. Again, I wish I had better answers for you in terms of the status, but like we've all seen, this has sort of been a slow moving change. June 3rd is when the appendix moving employees was published in that executive order. And so we're all still investigating and analyzing, what to do next. I think there are some helpful things that, the listeners on this call can do to further litigation as well, however, though, is to be in touch with your unions. So if you are in a union, whether it's AFGE or NTU or another union, make sure that you are talking to them. Make sure that you are telling them about what is happening to you. If you're not in a union, but you know that a union represents employees at your agencies, you should also reach out to the union and let them know, hey, I have information. What is the best way I can provide it to you? Then, Laura will be talking later, and Suzanne talked about Rise Up. Make sure to go to Rise Up to talk about what is happening to you, to maybe be connected with an attorney, or to be connected with your union. And the reason it's important to talk about this, there's so many reasons it's important, right? But one reason is for the litigation, right? The facts that we gather, facts that our partners gather, will help inform what they do next, and how to seek additional relief for employees who are transferred to Schedule PC. I think, one other thing that sort of this ties into, and I think we've covered most of it, but I think it's important to highlight is, being moved to Schedule PC does not eliminate all of your rights. And you should still be aware that you have some rights. And again, going to Rise Up, going to your union is a way to view those. EEO rights presumably still apply. There are still rights, USERA and other rights for people in the military and veterans that may apply. And there is still potentially prohibited personnel practice or OSC rights. Again, we know what the goal with this policy is. It's to take away those rights, but there are some that still may apply. And so I think it's important for you to remember to take that to your unions, to Rise Up and to others to sort of explore what options you have if you are transferred. So that's sort of the big overview. Again, there's a lot of questions still, but one thing to be certain is that there are many, many different organizations, including AFG, the AFL-CIO, and unions that are trying to litigate this, not only for our members, but also for our members' supervisors and for our members' supervisors, right? This affects us all. Even if a union member is not put on Schedule PC, the fact that his supervisor or her supervisor is put on Schedule PC is still an important and a major harm to our members. And so, again, that's sort of the general overview. Yeah, thank you.
Rishabh, thank you for that helpful overview of that. One thing, not just for cases around Schedule PC, it applies, and it's a question we've gotten for other litigation out there on various actions that the administration has taken, is somebody's asking, do you have to be a member of a union or the particular group that's brought the case to be covered by whatever the lawsuit eventually, what happens with that?
And so that is, and if you've been tracking the Supreme Court decisions over the last years, and you've heard of the CASA decision and other decisions, so it can vary in different cases. The Schedule F litigation that we are part of, right, we're asking for vacating the entire Schedule PC rule and asking for relief that we believe the court can grant to everyone who is affected by it. There are other cases where that may not apply. We may not be able to get a remedy that would apply to all individuals affected by a rule. But when we have the ability to try and seek universal relief, we still do so, and that is what the case here is trying to do as well.
And then an interesting question for all of you on this. Well, two questions that I'll ask. One, we have somebody in the Q&A asking if what do plaintiffs need in order to have standing? Do employees have to be fired for these cases, or for them to come talk to you all for support? I think these cases right now are about the law, just to clarify about the legality of the law itself, not particular actions against individuals. Is that correct?
So the cases have different sort of theories of standing. I mean, and this is a question that we're all, that's being, discussed internally as well. But, we are pursuing these cases as organizations because, it affects our members. Again, whether or not they are directly affected by Schedule PC. And so sort of in terms of we don't necessarily need an individual who has been affected by Schedule PC, they don't need to tell us who they are to potentially get relief. But again, it's important to gather that information. That's kind of where what I can say right now. There's the standing question gets very complicated. And again, it depends on the differing claims have different sort of standing requirements.
And I think right now, I'll go back to Suzanne and Laura. You mentioned if people have questions about whether they have standing, whether they can appeal, whether they have other avenues, that's go talk to Rise Up or, a union to do that.
Absolutely. And I think that this does there is a delineation here between challenges to Schedule PC as a rule and Schedule PC conversions. Just the act of being converted to Schedule PC, is that enough to deprive somebody of a property right that they once held interest in their civil service job, and all of those legal theories that Rashab just laid out? And then on top of that, there would also, the question is there a challenge if an adverse action is taken against somebody like removal after they've been moved from the general schedule to Schedule PC? And so that's a separate question that I think attorneys are going to be addressing, and I'm sure we'll have more information about that. At Rise Up, we do a weekly newsletter that we try to keep everybody updated on various litigations that are going on. The unions are taking the leads here. We're following all of that and tracking that as well. So if you do have any questions about whether or not a civil lawsuit applies to you, that's a question you can also bring to Rise Up. We can help you find that out.
That's great. There's another interesting question. Suzanne, this might be for you or Rashab, for others, is we've talked a lot about just in general, people being moved to PC, but one of our listeners has a question about whether somebody can be moved from Schedule A to Schedule PC or from a different schedule into Schedule PC.
I mean, I think the attorneys that are being moved in are moving from like C to PC, right? So I think they're coming from all the ones, right? I don't know, Mike.
Yeah, so it's a movement of positions based on the characteristics, not so much of what schedule you're in. So you're going to see a lot of competitive service folks, but also many in accepted service schedules, including Schedule A. Schedule A houses, for example, attorney positions. And if you look at the appendix, there are a variety of supervisory and management level attorneys who have been put into Schedule PC. So to answer your question, yes, and possibly from the other schedules too.
Yeah, Mike, like for example, somebody may have been brought into the government under Schedule A because they're a person with a qualifying disability, right? And that wouldn't, though, stop them from then being moved to Schedule Policy Career just because they were brought in through Schedule A, and then they would lose they would become at will in that instance, right?
Right.
Yeah, and I think the one thing though to that point, but Mike, I'll go back to something you said very early on, is that the senior executive service though is different, and the way the Schedule PC executive order is written does not apply, as far as I understand, to the SES, if that's your understanding as well.
That's correct. So the exception that Schedule PC relies on only applies to competitive and accepted service positions, not to the senior executive service. That's a separate service and has its own set of adverse action protections that are not impacted by Schedule PC.
One clarification on there, and this hasn't come up as a question, but just I think so folks understand, there's also senior technical and senior level, so SL and ST. Some of those, and I don't know, this is where you get into the really wonky details of how the civil service works, but while they are akin to SES in many rules, they may be covered differently because I believe SLs are in the competitive service. They're not in the senior executive service, so they would be treated differently. Is that correct?
I think that's right. And add another wrinkle to this. So Schedule PC applies to employees hired under Title V of the U.S. Code and have the adverse action protections under Title V. You may think, am I one of those positions? Likely, yes. There are certain agencies that have separate hiring and firing authorities. Many of those still kind of cross-link to Title V, which makes it even more complicated. But SL, ST positions are so different. I would just leave with that caveat that you might just want to inquire whether your position could be included if you are in one of these positions.
And again, this is a lot of questions out there. Rob, you look like you may have been jumping in.
I was just going to say, one of the things that's been on my mind since this came out is what employees should do if they get notification that they've been moved to Schedule Policy Career and they look at that appendix and there's no job that aligns to their actual job. Like, I am concerned that agency HR will be making mistakes in implementing the executive order And I think we don't know what the legal remedies are when those come up. And so the advice to go to your union with that, or if you are represented by a union, or go to Rise Up if you are not, to raise that issue. I think that's important for the lawyers to know who are working on these cases, because that might be a totally different kind of claim.
Yeah, if I could add, Rob, I think it's a great point. And we have heard from folks who have a slightly different circumstance where they think that their position was put in mistakenly, and then what to do about that. I think it's unclear. The FAQs do have a process that they say if an agency determines it wants to move a position out of PC, so whether or not it's a mistake or not, the agency HR individual can then contact OPM. OPM can then notify the White House and have a process for maybe removing that position. Unclear whether that would actually work, but there is a contemplated process for that in the FAQs.
And I think the other question is, because again, these are positions moved in, and there might be multiple people under one position. And so, it's also about whether an individual could be so there's just a lot of questions in my mind on how that's going to play out. There's also a question in the Q&A that's somewhat related, is that whether we can explain why people with the same PD number, and you'll see those numbers in the appendix to Schedule PC, and the same fundamental jobs at the same agency or regional offices or even across agencies, haven't both been moved to Schedule PC. And I think, Suzanne, you talked a little bit about that earlier, and Mike and Rob, you've touched on it a little bit. Can you, for folks again on here, talk about, in my mind, somewhat arbitrary listing because of how broad the definition is of what qualifies as Schedule PC? And Mike, Suzanne, I don't know if you want to share again about the definition and how there really isn't clarity on who can be moved.
Yeah, so if you go back to 2020, when Schedule F was first trotted out in Executive Order 13957, this is at the end of Trump 1 in October, and they put out certain guidelines for agencies to recommend to OPM, and they were quite broad. So it included not just folks who work in policy or have policy in their title, but anyone who in the chain of the policy decision making. And if you touch policy, if you handled it, possibly you could be lumped into Schedule F at the time. That has transferred over to PC in a lot of ways. So the 2025 Executive Order had a similar guidance to agencies. If these positions have these characteristics, consider putting them into Schedule PC. So then OPM itself had to take these positions and then make a determination about what fit based on their analysis and their rules that they finalized, and then recommend those to the president. So I think that's caused a lot of confusion, because some folks in very similar positions to someone else in a different agency or even a different office, one might be in Schedule PC and the other one might not, but it's based on this internal analysis that's gone through this chain.
And to Rob's point earlier too, mistakes have been made. we can already see, we can already tell. Before we got on the call today, we were remarking that how lopsided this is so far as it's been applied to agencies. Information you're getting sort of from insiders who are there is like, even the HR people who are having these meetings with folks who are being converted to Schedule PC are saying this was rushed. We don't have an explanation as to why, in this division, this job classification is being affected, whereas across the hall, it's not. But it is being noticed that this rollout has not been consistent across positions, and it hasn't been consistent even within similar positions in different agencies, or parts of subsections of agencies. So I think that hasn't gone unnoticed, and there's a lot of questions about that in the chat too. And I think that is maybe a fact that is helpful to these lawsuits that Rashab was talking about earlier, in talking about the arbitrary and capriciousness of how this has been done.
And to that end, Laura, Rashab, you touched on it a little bit, but Laura, you as well, and Suzanne just said sharing stories, telling what's out there. What are things that folks on this call, or other people in federal service that watch this later, what should they be thinking about their options at this point, and what can they do regarding what's going on right now with Schedule PC?
So I can just kind of reiterate a little bit about what Rashab said of sharing stories, sharing them with your union, sharing them with Rise Up, sharing them publicly, both because, we want to know if you've been reclassified, for instance, and then fired, like all of that can impact the litigation. We could put you in touch. The lawyers who are litigating those cases are here, right? And that could impact the litigation. So I think it's really important that people share their stories. And also, it's really important just to note that like personal narratives about the civil service, who are civil servants, the important work that you all do are so important. We have had decades of special interests demonizing federal work, civil service, for their own goals, to shrink the federal government, to privatize what should be public jobs. And there has been, there hasn't been a successful countervailing voice to that, and we really need to bring that countervailing voice now.
And Rashab, I don't know if you have more to jump in there.
Well, I'll just add, and it sort of addresses one of the questions there about sort of, the question is essentially what else are we doing other than litigation? If this expands, if it goes further. And I think, Laura answered that in some ways. And I think from the union perspective, what we're doing is we are, as a collective voice, highlighting the issue. We are, and it's not just the unions, it's all of us together here, right? Democracy Forward, Rise Up, the partnership, we're all together highlighting how insidious this is, how bad this is for the country. And so it's important, again, to share those stories, to join your union if you have one available, if you're at an agency, to support the union even if you're not a member, and to support other organizations like Democracy Forward and Rise Up. And that support doesn't need to be financial. It might be, volunteering your time or, sharing your story. And so, we are doing, as a community, we are doing a lot more than just litigation. Litigation is just one piece of it. There is a lot more going out there, talking to your Congress members, et cetera. So I just want to make sure that, we highlight that we are doing more than just litigation here.
And I think that's right to really remind people, and you all have said that, is that one of the things that's so critical right now is that the general public doesn't always understand what government does in their communities, what federal employees do across the country. We often throw out the number that, at this point, it's almost closer to 85% of federal employees do not live in the DC metro area. And so these are folks that are just, as you all know, because you're on the call, you're doing the hard work every day out across the country. And so sharing those stories and making those ties to the impacts that federal workers have on the services that the public brings, that's something we're all trying to do as well, to create that understanding and awareness, both for the public, for Congress, for the media. So it's certainly something, and I think you'll see on all of our websites, there are places to share stories about what you and your colleagues do. And there's also a lot of alumni groups out there. A lot of the federal employees who left government over the past year and a half are really still so committed to the mission. And so they are out there also helping and supporting and doing that work. So there's a couple links that are in the chat, but there are ways to kind of see what else is out there and to get involved, to Rashab's point. I do want to, before we get too far down, and we can circle back to PC, but I think there are a couple other things that folks on the call who are listening in should probably be aware of other actions that are coming from OPM. They may or may not be aware. And so there's one on non-disclosure agreements. There's a couple other issues out there just to flag for folks. Rob, Mike, Rashab, anybody want to jump in on some of the other things that you all are tracking right now, just so people have these on their radar?
I'm happy to start maybe with the OPM proposed NDA. So a few days ago, OPM proposed a government-wide non-disclosure agreement form that agencies could use to have their employees sign. So this would be for applicants and for actual employees. So they're taking comments on that now. So if you would like to comment, this is a good time to do it. The comment period closes on the 26th of June. And there are, as you can imagine, quite a few harmful impacts to a government-wide NDA, not least of which would be your First Amendment rights to talk about issues of public concern. Rashad probably has a good perspective on how it would impact your union rights. But basically, the proposed definition of confidential government information, which is the centerpiece of this proposal, is so broad that it would cover any non-public information. So you can imagine you go home and you tell your friend or your spouse or anyone else about something that happened at work. That could potentially be used as a way to punish you or terminate you. And there are actually also criminal penalties that could be associated with disclosure of information. And the proposal itself listed a few kind of high-profile leaks that happen from government. So I think this is the administration's way to further harass employees into not disclosing what's going on in their workplace, even if it might be lawful. And it tries to carve out whistleblowing, but I think there is a chill that happens whenever you say, if it is non-public and we decide that it's not public, we can go after you. It really puts the employee in a position to really have to take a risk about whether something is an actual whistleblower activity or otherwise protected. So it is a bad proposal, and we have put out a comment guide on our website at Civil Service Strong. We circulated that, so feel free to go to our resource page to see that. If you're interested in commenting, I think it really helps folks understand the proposal and how best to approach a comment.
And Mike, Rob, are there other, Rashab, Suzanne, are there other issues that you've been hearing from feds about or tracking right now that you think it'd be helpful for people just to have on their radar to understand the scope of what's out there?
I mean, I'll just say broadly, and I'm not sure if we talked about this on a previous webinar, but there are several rulemaking or proposed rules that OPM has issued over the last few months that are changing performance ratings, changing how suitability is done, changing where you can appeal certain actions. AFGE, other unions, Democracy Forward, we've all been working together as a community to comment on these rules and to track them to make sure that when and if they become final, we can litigate them. I know there's a lot of information on AFG's website. There's a lot of information on Rise Up, on Civil Service Strong, but you should always feel free to ask your union or ask any one of these organizations for more information on those specific things. I know there's also been a lot of questions about relocations that have been coming up. And I know there's a lot of information on the internet about and through on all of our websites about sort of the rights you have with respect to that. But the one piece I wanted to put out on there is, if it's happening to you, if you've gotten what's called a management directed reassignment or a relocation notice, if you have a union, of course, tell your union. But even if you aren't a member or aren't in a bargaining unit, if you know there's a union at that agency, let them know, because they may be doing something about it for their members. They may be doing something about it already, and the information you provide may help prevent the relocation or the reorganization. This has happened in agencies in the past, and so just let your union know, let someone at Rise Up know, and we can try and get you the right place there.
That's great. Thank you for that. And we've put a lot of resources in the chat, but there's many, many more on each of our organization's websites. So certainly a place to go look for all those other issues. I know we're getting close to the end here, and a lot of people, we've gone through a lot of questions. If anybody listening has additional questions, please feel free to put them in the chat. I'm going to ask each of you for some final thoughts here, but before we do that, we do have a poll that my colleague Natalie will put out there for everybody who's listening. It just helps us regarding your experience, but also other topics, questions, things you'd like to hear about. And so please feel free to fill that out and let us know what else would be helpful, what other resources, because we are certainly all here trying to support you all and bring as much clarity to these unclear things as possible. So before we get to the end and close, I'd love to ask everybody here if there's last thoughts, last things you want to say to folks on here, both about anything you're thinking about with Schedule PC, any top takeaways, reminders of your websites too, and where they can go for resources. So maybe Suzanne and Laura, I'll start with you.
Just we'll reiterate the general advice, which is when it comes to that acknowledgement form with Schedule PC, you really have nothing to gain and sort of everything to lose if you fail to sign it. It's just an acknowledgement, it's just a receipt. I did talk a little bit in the Q&A, but we didn't address it here. OPM's own implementing guidelines do say that folks should not be punished for failing to sign that form. It directs agencies don't punish people for failing to sign that form. However, agencies sort of sometimes do what they do, regardless of what OPM is telling them to do these days, especially. So just it's a risk calculus to make yourself, but in general, probably don't have much to gain from it. And so usually at this point, if you're still in federal service, I think that generally means you want to be there. Your position is already becoming more vulnerable moving to Schedule PC. Keep your head down and work through your unions, work through the litigation that's happening right now to effectuate your rights. That's the safest thing you can do. There's strength in numbers, right?
And I'll just reiterate what I think a lot of us have said. There are a lot of people, the organization's resources here to support you. You're not in this alone. Your union, the other organizations on this call, we are here to help. So please reach out for support.
Yeah, there's certainly a lot of support. Mike, Rob, are there other resources or last thoughts you have for the folks listening in?
Yeah, I just may want to acknowledge that this is probably a really scary time for a lot of you. I mean, I was a longtime civil servant. I relied on these protections and I kind of took them for granted for many years, not realizing that one day they could be gone. So I can imagine that many of you are just scared, and we totally get that. So please reach out if you have questions. We can direct you as best we can. If there are individuals who are terminated after being put on Schedule PC, I think we'd like to hear about those, because that is a new front in the legal fight that we're trying to piece together in real time. So I know Rise Up has a great portal for reaching out. I have an email address. You can just email me. I take emails at all times. But really, this is a hard time, and I think there are really good legal minds thinking about how to bring the fight in court. And I think there is a reason to hope, because there is such a great coordination amongst all these groups and others.
Yeah, I would just add to Mike's sentiment there. I think you heard today that there's a whole lot of legal thinking going into this. These organizations have been on this issue from the very beginning. The day that the first executive order went out at the very beginning of the administration, litigation was filed. It's all being actively handled. The people are thinking about each step this administration is making and how it affects the legal arguments and how to get the court to issue rulings to like strike down the whole regime, right? Like that's the goal here, is the whole thing is deemed illegal and anybody that was put on Schedule Policy Career gets made whole. That's what we're going for. But in the meantime, you're getting these confusing messages, you're being told you're at will. How do you carry out your job day to day now that you are being told that you're at will? Why are they saying that you're at will when people doing the exact same job in other agencies or even on your own team aren't being told the same thing? It's all very disconcerting. And I wish that the courts recognized that that is a problem in and of itself that requires immediate action. Unfortunately, they often don't. They often, go through the regular process that we're going through now. And that's the way that they take up these employment cases. And so that's very difficult. But I think the other thing that I would emphasize is if you are put into Schedule Policy Career and things come up as you're doing your job that create concern for you about, okay, this is something I saw that looks really bad, but I'm now on the Schedule Policy Career. What should I do about that? Again, reach out to the same resources that we've talked about today. We'll be here for you while you're dealing with what it actually means to be on this Schedule Policy Career until such time as hopefully the whole thing is shut down.
Thanks for that, Rob. Rushab?
Thank you, Jenny. Just a couple of things. First, thank you all for everything that you do. If you are a federal employee, or if you're someone here to support federal employees, thank you for that as well. And then the second thing, I just want to reinforce one thing, and I think it's important that all federal employees reinforce it to the broader community, and that this is not just about jobs, right? It's when you think about Schedule PC, a lot of the news is, oh, it makes it easier to fire people. People are going to lose their jobs. It's not about that. It's about what you do as federal employees. And this is important for legal arguments too, right? This is not about, whether or not certain people have jobs or not. It's about their ability to carry out their duties to serve the American people in a non-partisan way, and to provide the services Americans expect. And I think it's important to reinforce that. What we're fighting for, we are fighting for your jobs, but we're fighting for your jobs because you care about what you do and you care about the American public. And we need this system to protect our democracy and to protect the services that we all rely on. And so, again, I think that's just an important thing to reinforce, both because it's important for litigation, but it's also important for, congressmen to know, and it's important for the public to know, so they understand how important this issue is. That's it.
Yeah, thank you, Rashab. I mean, there's just so many things that folks do. And I know, as you all have said, one, it's important for so many reasons to flag issues that are going on. There's been folks in the chat who have said, one, thank you to all of you for being here and helping answer questions, but that they don't always know where to go. And so I think hopefully tonight, it's clear all of our organizations are here to help all of you. And if we don't have the answer, there's a lot of other organizations that are out there beyond the 3, 4 that you see on here that are also helping folks. The unions, there's a lot of other nonprofit organizations. There are whistleblower groups. There are groups like the Federal Employee Education and Assistance Fund that help feds. There's so many different types of resources out there. I think the biggest challenge where, we all work to get the word out as much as we can. But for those of you listening, please share with your colleagues, share this webinar, share, some of the resources out there, because they're really there for all of you. And so the more we can help feds know they're not alone in this and that there are a lot of us out here, we are happy to answer questions and just point people in the right direction. So please reach out, please share. This webinar is recorded. The webinar will be sent out to attendees after, along with the links and resources that we shared in the chat tonight. So those are things you can share as well, or come back to our websites and see them. And just want to say thank you to all of our panelists for being here this evening, for sharing all your information. Really appreciate it. I'm sure I will see you all on future town halls. I guess unfortunately, because that means there are more questions that we have to answer, but fortunately, because you are all here offering great perspective on these. So thank you all for being here this evening. And thank you to all of the feds and former feds out there. We see you, we appreciate you, and thank you for your service. And with that, I'll wish everybody a good evening.